Yes. Your Lordship, I'm praying for lifting and indemnity application. I filed today, Your Lordship. Friday? Tomorrow, Your Lordship, because the date is tomorrow. For what? For retiring him. Yep. Friday. No injury order. No. Why are you waiting for the last day? Because it has been issued on 20th, Your Lordship. The order has been issued on 20th. All right. I'm deeply aware. Government taken 4 weeks time for inspection on 5th December, madam. Here's the rough inspection. For admission. For admission, madam. Have the government of taken it? Okay. Title proceeding. If 1920 and 7. 7. I beg to mention this for listing of this analogous PPT. It's already tagged. Yes. March. That is your lot. You're after that. 17th of March. Why? The urgency is that DPC is going to be held tomorrow. So only yesterday we have got the mail where I have been asked to appear for DPC tomorrow. So we have filed it very urgently and it has already been filed. So as last item today or first item tomorrow, because DPC is going to be held. DPC is held to for what? For promotion? Yes. Now the problem is for that promotion. Yes, for promotion. But I do not want to be I do not want to be part with that DPC. Why? Because I am one of the members who have actually proposed regarding changing of draft. Some rules are there. The Assam Institute for Research for Tribals and Scheduled Castes. And now already it is in the discussion. And I'm one of the members of the drafting committee. Now what has happened is that in between this particular ongoing discussion and the suggestions by the director, now this DPC has been held. And now I have been asked to appear. So if it appears, it will hamper because I will be promoted. Don't appear. Why do you want an order? No, why not? Because to stay the DPC at this. Why? Because already doesn't concern only you. No, my lord. It concerns other people also. No, my lord, absolutely. But now the problem is that I am the deputy director, my lord. And if my lord, if I appear tomorrow, then I will. Don't appear. My lord, absolutely. But the DPC already. Why should we stay? Why? Yeah, my lord. Everybody. No, others who are not concerned. My lord, I have a genuine case, my lord. That is why. We'll examine it. Absolutely. That is why give us a chance, my lord. At least since tomorrow is the day. So I want to at least hear it, my lord, as the last item. Last item. At least hear it. And if court is pleased, then court can apply. I please your lordship. That I beg to mention item number 6, lordship. Yes. Lordship, in this matter, instruction is awaited, lordship. For the petition. Hey, Patwari, lordship. Where is he? Informed him over call.
Item 6 on the request made by the
Interim is ordered.
respondent stands referred to be listed after 2 weeks.
Interim is in their favor, Lord. So interim.
Counsel for the petitioner submitted counsel. Consent of the counsel for petitioner. 18 March. It is a short date, 18 March is just around the corner. 27. Yes. Consent. Yes. I think 7 or
I am correct for this thing.
18 March. Come this side. This, some of you can come this side. Yes. Second of March. 3rd March. 3rd March. 3rd March. Published. March. 23rd March. Published.
We have received instruction like to file a short appeal. 1 week's time may be given because a lot of posts are there. Not a difficult proposition, but they were rejected on merit. Although this police verification, that is not there in that. If a police verification is done and there's some right has accrued, but we'll give every details in our. 1 week time. Lot of posts are there. It is on record.
Is this matter again on
11th or 12th. I'll
11.
file it within 1 week. If they want to file counter also.
11th March.
All done. We have done it.
Appointment has taken place.
Highly obliged.
Step. I know.
I retired. They are on 26. Action, my lord, will find it. Era 16 and 17. Para 17. They have to prepare the proposal, pension proposal, and send it to the AG.
Stage of the criminal proceeding.
Customers, there's no custody you can find.
Yeah, receiving, receiving it. Most of the people.
Exactly like that. Why this matter has been posted repeatedly. You have to
What is the,
see from
what are the, what are the particulars?
No, not even charge sheeted, man. Investigation. State investigation. Fire dated is 29/9/2020. When this order was passed, there was no charge sheet.
Yes, Mr. Goswami. Can you give the status of an ACB? ACB PS case number 11 of
2020.
ACB PS case number 2020 of the section 7. Status of this. We'll record your name in the order. Status of 15th of March. Based on 11th March.
That after that, my lord, that hearing. This time, my lord, that some,
iPhone. anything. Implement petition. You file your counter here. File it. What is easy got to do? File it.
He has already refused to
Notice
grant
that the matter was issued on 91/2026. Thank you. Thank you. Not fine. Thank you. Dates are not listed. If no dates are fixed. What tell us? How will I know? Unless you tell us. After 4 weeks. 7 March. With I got a 1 minute of down. LC and HLC. I love it. Then you will see. Fine.
Page 27, Your Honor.
Seven, my lord.
Directed to farming. Was approved by the state level committee itself for appointment on company town at Dorong district. I number one so dated 4/9. I am directed to sign card for appointment on compulsory ground in respect of his son of thereafter. Yes,
SLC approval.
SLC approval is your I have. At that time, I have not done. I have next in my reply, Your Honor. Page 21. Number one, order honorable court, order Your Lordship.
It is no more.
My lord, so much. Then that was disposed of, my lord, by the honorable court, Your Lordship. I ordered that Your Lordship, the fact appointment, Your Lordship. The fact appointment not in procedural, but they say they estimate that I was appointed on compassionate, but it is not a compassionate ground appointment. This is appointment made by the someone by the fact appointment, Your Lordship. So, thereafter the honorable court call for the record, but they are unable to produce the record where what I have submitted, that I have not won that service.
Hmm?
They say that I have declared that I have not required a service. Thereafter, I have read before you the honorable court that the order, the letter which has been submitted by the petitioner, that should be submitted. That is the original order should be submitted.
There is an inquiry report
Fine.
which was placed before CID inquiry report,
There is an inquiry report.
where it says that you had joined under the Director of High Service.
Instead of fact appointment matter, it is not in procedural matter. Someone a boy for his surviving, he may be engaged anywhere by for his livelihood, Your Lordship. But this is a not procedural appointment, Your Lordship. They also stated that this is a fact appointment. The CID itself, their affidavit in opposition, they have stated, Your Lordship. In the document, their reply, my reply, Your Lordship. Age is about, Your Lordship, now as per that 45. Fine. Compassionate ground appointment, Your Lordship.
You are 38 years on the date of filing the report.
But now, as per record value, 45 years. About 45. Now, as a compassionate appointment, Your Lordship, he may be entitled, Your Lordship.
When did your father expire?
Other expired, Your Lordship, will 1989, I think.
Then after all,
That the GLC approved my name, Your Lordship. Your Lordship will find GLC approval. Page 21 in my promoter contempt. Your Lordship. Page 21.
who's for the government? Do you have?
Lordship,
You
I
have
am
the
appearing.
pleadings available with you?
Yes, Lordship. I have brought
In
the copy
in
from
the
the.
content matter,
Yes, Lordship. Here, basically, Lordship, our affidavit is, everything is stated in the affidavit, Lordship. Yes, Lordship.
we want to ask you that besides the petitioner, there are other names. From where the petitioner-
I am not another person. The petitioner was offered appointment. We have categorically stated in our affidavit, Lordship.
He refused.
He refused because he is telling I am not accepting the post of grade 4 employee. He is working somewhere else, Lordship. This is his contention. And we have stated this in our reply to the paragraphs of the
But
petition, Lordship.
ultimately, in the suo moto content,
Yes, Lordship.
there was some CID inquiry.
Yes,
conducted.
Lordship.
CID inquiry concluded that he was appointed surveillance.
Surveillance. He himself stated, Lordship, this is in our, if your Lordship kindly peruse page 43 of the affidavit that we have filed. Paragraph 3, we have that Lordship, we have urged the ground of maintainability of the writ petition, Lordship.
Which page are you on? Affidavit.
Lordship, running page 42, Lord. Paragraph 3, the affidavit filed by the state Lordship. Paragraph 9, Lordship. That with regard to statements made in paragraph 7, 8, 9, 7 to 16 of the writ petition, the respondent has no comments to offer in respect of those statements which are matter of record. The answering respondent also
Where did his father serve? Where was his father working?
Father was working in the police.
Which department?
Police department. Lordship, then A, B, C, D, we have mentioned everything, Lordship. After approval of the petitioner's claim for compassionate appointment by the state level committee in its meeting held on 13/8/2008, the matter was processed for appointing the petitioner. And after receipt of the letter dated 2010-2012 issued by the Superintendent of Police Dharan providing the required information in the prescribed format, the then Additional Director General of Police Admin Assam forwarded the aforesaid forms to the Deputy Secretary to the Government of Assam by a letter dated 6/5/2013 for obtaining SIU approval. Thereafter, Deputy Secretary to the Government of Assam Home A Department by his letter dated 30/11/2013 intimated the Director General of Police Assam as regards the appointment of the petitioner on compassionate ground for the post of grade 4 boatman, as at that relevant point of time there was no vacant post of junior assistant under 5% quota for appointment. Then, Lordship, after receipt of the aforesaid approval, the ADGP Assam by letter dated 17/12/2013 directed the SP Dharam to issue appointment letter to the petitioner after satisfactory verification of character and medical report, etc. and to submit the proposal in format A along with copies of appointment letter, joining report and undertaking for new pension scheme after his joining in the post for his release of salary to the Assam Police Headquarters. The copies of the annex, Lordship. Then B, Lordship. The Superintendent of Police Dharan by his letter dated 22/12/2013 informed the petitioner so and so to report at Police Reserve Mangaldoy for processing his appointment. Thereafter, the petitioner by his letter dated 25/12/2013 informed the SP Dharan that he had already joined in a post of junior assistant in health department in Bongaigaon district and therefore he cannot join in the post of grade 4 boatman in Darang district. After receipt of the petitioner's reply, the SP Dharan by his letter dated 1/1/2014 forwarded the same to the ADGP Admin Assam and Deputy Secretary to the Government of Assam Home A Department. And as the petitioner refused to join in his service as per his selection for appointment on compassionate ground, the matter has been closed by the authorities at that stage. So this is, Lordship, the fact. And Lordship, it has been observed in the contempt while disposing the contempt case also, Lordship. Because as writ petition is pending, so this has not been dealt there, Lordship. Your Lordship kindly peruse the.
Now, what is your stand with regard to the claim? That you have joined?
Why you I have joined. Yet I pray before the court, let them to produce the record that I have not required their service. They are unable to produce the original record. The Xerox copy they have submitted. But thereafter I pray before the court, let them to produce the original record. If they are able to produce the original record, then matter will be solved. But they are unable. You will reply, your Lord.
Mr. Counsel, we are not here to conduct an inquiry. If there is a false, incorrect letter, why do we
provided there, please actually attend.
We have
On the
understood that.
basis of that,
We have understood that.
I have filed a writ petition also before the.
You have filed a writ
They have
petition.
given the several opportunities to file their affidavit. They have not filed their affidavit. They have no pleading. After 3 times you will also, they have given the chance. They have not filed any affidavit. Hereafter, the honorable court passed an order to appoint me on the basis of SLC approval. You will not see.
You are said to be appointed as your assistant.
Your assistant.
When
SLC approved my name. Your Lord.
you said according to the state you were filed the appointed as your assistant.
No appointment.
Your assistant on health department.
My Lord, health department, this is the fact appointment they say. But I was not appointed on compassionate ground to the post of junior assistant. Your Lord. DLC and SLC approved my name to the post of junior assistant, but they were not appointed me, man. That is why I filed a writ
Once
petition.
the recommendation is made by the SLC, you will recommend.
But we have stated, Lordship.
Well,
Lordship, in page 44, Lordship, the continuation of 9A, Lordship.
yes.
The so and so, Lordship, in the fourth line, Lordship, from top. Thereafter, the Deputy Secretary to the Government of Assam, who made department by his letter dated 30/11/2013, intimated the Director General of Police, Assam, as regards the appointment of the petitioner on compensation ground for the post of grade 4 boatman, as that relevant point of time there was no vacant post of junior assistant under 5% quota for appointment on compassionate ground. We have mentioned, Lordship.
Now, who was appointed in? Supposing he did not join, what happened?
That we are not, because this has been offered to him, Lordship. And page 58, Lordship.
This vacant post of boatman
Yes.
under which department?
Obviously, of the police department, Lordship.
Police department is boatman.
Here, it is saying so, Lordship. 1 minute from the. Yes, Lordship, kindly peruse page 56. Page 56, the letter, appointment on compassionate ground. With reference to the subject above, I am directed to inform you that the Government of Assam Finance SIU Department has approved the name of Sri Apurva Kumar Nath, son of so for appointing him on compassionate ground for the post of grade 4 boatman in your office establishment.
Find out who is there in boatman office now.
Lordship, then peruse page 58, Lordship.
Disputing this letter saying that
I'm willing to join for the post of
we
grade
just
4.
want to know who's appointed in this post now.
13, Lordship.
So the post was
Special opinion, sir.
under the office of what is this? Superintendent of police. By its meeting. contempt petition with you. It's 24.
Take time, you will.
Finalized, Lordship.
Huh? And like. The policy decision has been taken.
Not taken, Lordship.
I think up to section 6. Section 6. At page 59.
Just 1 minute. Clear that you want.
Right.
That would be subject to the rules being adopted.
Yes.
Now there is a guideline. The parameters are defined.
But the policy decision is yet to be taken.
Now this policy decision, my lord,
Can there be a direction by the writ court
My
that
lord.
the policy decision in this manner, that manner should be taken? Then
but my lord, this is not from
but it is premature, they are yet to take a policy decision, they are not declined.
to page 7, my lord. Page 8. Page 8. Paragraph number 4. The petitioners beg to state that the Honorable Supreme Court of India on 81/2010 had passed an order.
Where is that order? Is it available here?
My lord, is not available in the court order. My lord, this is not guidelines which has been issued by the Honorable Supreme Court. The first point has been satisfied that welfare boards have to be constituted by each state with adequate full-time staff within 3 months. My lord, that is a part of Annexure 2 of the petition. Now, my lord, will kindly come to page 10. Page 10, ma'am.
The rules have not been adopted. What governs your services now?
My lord, as per their HR policy,
Board has prepared the draft rules,
the board has prepared the draft rules.
adopted it, I mean approved it.
Approved, not approved. My lord. The approval has to come from the government. Now, what has happened is that my lord, the last annexure, my lord, will kindly see. The last annexure is at page 120, 120, regarding the to and fro. This is from the Labour Commissioner, Assam. And this was directed to the state, my lord, in the welfare department. This was dated December 2017. It says, my lord, the first paragraph. In inviting reference to the subject and letter cited above, I have the honor to submit afresh the draft rules after all the necessary rectifications and deletion of clauses as sought for as per observation of the personnel department. In this context, a statement of correction of clauses also has been prepared and posted any reference. So the last instance of draft service rules have been drafted incorporating the type of the state. Thereafter, in the affidavit in opposition, my lord, the state has referred to a letter dated 24th of March 2021 at page 143. 143. This is again the last communication
which has been referred to by the state, my lord, that the Labour Commissioner has referred before the Labour Department, the government. In reference to the subject cited above, please find the attached service rule incorporated the following inputs from the Social Welfare Department. This was 2021, my lord. And we never takes one of the expectations of the mind of the mind of the
Judgment, you are not able to place it before the court except for an extract. Your entire case is based on the Supreme Court judgment and you say it is not available, old judgment.
my lord, it is, my lord, the relevant portion is not the fact that
Forget about repeating. You come before the court along with all whatever details you have. You want to see the judgment. You've seen it. You have referred to it. See the judgment. The pointing things that court finds in the council. Please come to page number 31.
my lord,
Said that it is not available.
no, my lord, I said it is not.
It's perfectly legible. Perfectly legible. You said it is an old order, it is not available.
No, I said, my lord, it is
Said that because you said it was an old order, you don't have it and it's a relevant extract is there. You can replay the recording if you want. We give you audience doesn't mean that you take it for a ride.
my lord. Always, no.
Come back prepared and address the court. No, we are not fixing a date. Mention it. Mention that you're asking for is what? Rude. At a come in the English that you have written said it, but Some authorization required.
The JB authorized. Right. And that authorization was followed in respect of the contract to be executed. It does nowhere clause 8 mentions authorization regarding filing of the well, claim regarding any dispute. It only says to sign, if I may read clause 8, it says sign the tender contract agreement in respect to the tender payment to witness one measurement of work done, to sign measurement book and all letter correspondence related to the above. But regarding filing of this,
That is
The entire currency of the contract, including the period of extension.
status. After completion of the work.
Like to by the railway.
Right after the firstly, whether content and these will appear in the
I've gone out of the group center without permission, and that there was some minor scuffle that had occurred at the petrol pump. And thereafter, I was arrested briefly, and since the charges were available, I was bailed out, and then DP had started against me, my lord. The main allegations were that under section 11(1) of the CRPF Act, which said that I was guilty of disobedience, neglect of duty, remissness in the discharge of duty, and other misconduct. So, my lord, when the memorandum of charges were filed against me, the charges were mainly of unauthorized leave from my post. The first petitioner, that is Dukmajyoti Gogoi, was posted on guard duty, and the and the petitioner in the second case, Biplab Bora, he was manning the quarter guard duty. So the allegation was that without prior information to the competent authority, they left their post and gone out of the post for other work. So while the memorandum of charges were limited to that, during the period of inquiry, certain additional evidences were brought in, and wherein it was alleged that I had assaulted and I had also threatened.
Where is the charge sheet?
The charge sheet.
Nature one.
The inquiry report, my lords, finds at page 44. One and two, my lord, the limited aspects that I had left the premises without the permission. But if my lord reads through the inquiry report, certain evidences were brought in which were not listed in the memorandum of charges, and certain other statements were brought in, certain other allegations were brought in, and I was mostly the charges against me were found to be proved on the basis of those statements. They never put up to me in the articles of charge. And my lords, that this inquiry was conducted by a person in the rank of deputy commandant, my lord. Whereas as per the act and the rules, it is supposed to be conducted by the commandant. That is one information, my lord. And this inquiry report was upheld by the commandant by relying on these extra evidences, my lords, which were never put up to me. I have certain judgments of the Honorable Justice Court as well as the High Court. Yes, ma'am. I will kindly take my lords to the articles of charge that are served to me. My lords finds it that (29), my lords. Description of articles is at page 28. So I will kindly read, my lords. Article 1. That post number so and so, CTG.
What is page number 28?
My lords.
28.
28.
Okay, 28 is before.
Yes.
Then 29.
No, that's page number 28 of the requisition number 448. That,
Both, my lord. Both.
yes, it's a common inquiry, my lords.
Okay.
Both the names are there, perhaps.
All right.
Yes. Article 1. That force number so and so, Constable GD JJ Gogoi and force number so and so, Constable Dr. Bora of Group Center CRPF, while being posted at CTGD, had committed an error, committed an act of disobedience, neglect of duty, remissness in the discharge of duty, and other misconduct in his capacity as a member of the force under section 11(1) of the CRPF Act. And in that, on 27/5/2012, force number so and so, JJ Gogoi, while on RP duty at gate number 2 from 600 hours to 1700 hours, and force number so and so, Biplab Bora, being on quarter guard duty from 1600 hours on 27/5/2012 to 1600 hours on 28/5/2012. But on 27/5/2012 at 1600 hours, using duty check, change of duty, both employees are found absent from their place of duty. Their act of leaving the place of duty on their own will while detailed on duty in active duty quarter guard in sensitive area is against the good conduct in the force and is grave misconduct and is against the order and discipline of the force. Article 2. That force number so and so JJ Gogoi and Biplab Bora of Group Center CRPF Gauhati, while being posted at CTGD, had committed an act of disobedience, neglect of duty, remissness in the charge of duty, and other misconduct in his capacity as a member of the force under section 11(1) of the CRPF Act. In that, on 27/5/2012, force number so and so JJ Gogoi, while on RP duty at gate number 2 from 600 hours to 1700 hours, and force number so and so Biplab Bora, being on quarter guard duty from 1600 hours on 27/5/2012 to 1600 hours on 28/5/2012, but while on active duty within group center premises without any permission, prior information to competent authority, they left the camp premises on their own will, quarrel, threatened and used abusive language against the employees of Bokadan filling station petrol pump, by which the image of the discipline force like CRPF had been diminished, and which is also against the good conduct in the force and in an act of grave misconduct and against the order of and discipline of the force. The two articles, madam. They will limited to my act of unapproved leave from the premises. Thereafter, my lord, this statement of, and thereafter the list of documents which we have sought to rely on was given to me at page number 31. My lord, looks to the document number 2. Charge document number 2, letter number Bukazan police station case number so and so dated 35/2012 under section so and so IPC, issued by officer in charge of the Bukazan police station, which was in relation to the medical report of force number so and so JJ Gogoi and force number so and so Biplab Bora of this group center, and also in regard to both the persons being intoxicated and fighting and threatening the employees of Bukazan police force.
Where is the medical report?
That is the thing, my lord. That medical report was not there. It was never furnished to me. My lord, this document was never mentioned in the articles of charge to me.
Which document?
This medical report, my lord.
Yeah.
No, it has
List of documents.
my lords to the charge sheet in the connected criminal case, my lord. It is at page 24 of this writ petition. Therein, that medical report was never put up.
So how is the criminal case related?
Charge sheet, Gogoi was acquitted of all the charges. Therefore, nothing, nothing stayed.
No, there was no charge sheet filed against him.
Charge sheet was filed, but
It was not filed.
yes, it was filed, my lord, but I was not found to be guilty of those penalties. So I was not sent up for trial. It is at page
Fine.
24, my lord. Therefore, my lord, to rely on the so-called medical report, and during the entire departmental proceeding, this medical report was not served upon me. My lord, the letter that is being spoken about is merely the letter.
Where is there a medical report available in the reports?
My offense at the most would fall under section 10M, madam. Section 10M. That too partially, madam. Section 10 deals with less heinous offenses.
Why not under 9H and I?
Legally, I put my guard. I was on duty that day. Only for some point of time, I had left my
Nine I.
I put guard to take partly of petrol without being regular. That when I had left the group center, I had signed on that in and out register, and then I had got out.
That is for,
So it was never my intention, my lord, to
that
abandon.
is not for both, for only one person.
Yes, my lord, that is for Jugma duty.
Uh,
I have also for the second person, my lord, because at different point of time, both have left, and they had met at one point of time, where Jugma duty got onto his bike, and then they left together, my lord. But the point of leaving is different, my lord. Met. Get some cash out of the ATM, madam. So the ATM inside the campus is not working. Was acquitted.
Final report was some.
Yes, madam. At page number 24, madam. In the second column, my lord, not sent up for trial, Shri Jugmajyoti Gogoi. And but on the next page, at page 25, in the rightmost corner, my lord, in bold it is written, it is humble prayer to acquit the arrestee, Shri Jugmajyoti Gogoi. He was acquitted of the charge. During the
And what
investigation.
about the number two?
Number two, he had pleaded guilty, and he was, and a fine of 1,000 or 2,000 was imposed upon him by the executive magistrate person. He had admitted to his guilt, my lord, but even then, my submission is that the punishment that was imposed upon me was totally disproportional to my conduct, my lord. Therefore, I pray for a lesser punishment. It also includes my,
What is the order passed by the disciplinary?
my lord, the order would be, it starts at page 63. The observations of the authority would be at page 65 minus para number 7, where the commandant had found his satisfaction based on the inquiry report. It starts at para 7 at page 65. If I may kindly read. Therefore, after carefully going through all the evidences of the witnesses, documents, report of the inquiry officer, I, the undersigned, have reached a conclusion that the inquiry officer had been given full opportunity to the delinquents during the inquiry process for the evidence. The inquiry officer has found both the articles completely proved against the charged employees, and I agree with the evidence of the witnesses, documents, and the inquiry report in which the following facts have been fortified. Number one, as per PW 3, 6, and 8, Force number so and so, Constable J.J. Gogoi threatened HCGD, Head Constable General Duty, Dhananjay Dwivedi, CHM, that after coming out of the police custody, will not leave you alive and I will kill you. Kacha khao jaunga, which the delinquent has accepted. This thing was never put out to us in the memorandum of charges, and we had no occasion to verify it. Neither could we test it. Secondly, my lord, as per evidence of PW 9 and letter number so and so, Bukajan, PS number so and so under section so and so, Biplab Bora and JJ Gogoi were kept in custody at Bukajan police station. But here it was not considered that Jugmajyoti Gogoi was not, no materials were found against him and he was acquitted. He was paid to be acquitted. That was not considered. Thirdly, as per evidence of PW1, the complaint given in the form of representation by PW1 against both the delinquent may be treated as evidence. My lord, he was not examined and his complaint was sought to be treated as evidence. It is described here that Constable G.D. J.J. Gogoi and Constable G.D. Biplab Bora had misbehaved with the officer in charge, Bokajan Police Station, and Company Commander 155 Battalion, which both the delinquents have accepted. This is another allegation, my lord, which is not put out to me.
Where are the evidences of the witness? Easy, time. Don't you said 1 week time. You are seeking a reference for arbitration.
Yes, Your Lordship. And Lordship, they have filed an arbitration petition before some other court. Here they are disputing. They have already filed a.
Then you come back at 2 o'clock.
Lordship, may kindly give me 2 o'clock at another metaphysics.
Selection which was conducted.
That time 25% was for the promotion quota. Understand? The promotion quota was fixed. Okay. Therefore, this vacancy was simultaneously existing. As a result, this was not advertised. This was meant for the direct recruitment.
Now that post is filled up by the private respondent.
Internal promotion.
Whatever, filled up by the private respondent.
Private.
Are you telling the point?
I'm not saying that subsequent selection.
Vacancy fell because of certain. Private respondent.
That year, man.
Subsequently, you are promoted.
That post, my lord, wouldn't have been advertised for internal advertisement or anything. Because it would say, my lord, even the no, my lord, subsequently other vacancies have also come, my lord. My lord, my case is, my lord, to get over this one, if the gentleman and response, my lord, response 7 months, it can be adjusted in subsequent vacancies which they have. Even now, as of now, they have again advertised to post for internal my lord, promotion.
You apply.
My lord,
You apply.
I applied the DPC one when not knowing that my name was already there. Not knowing that my name was
Mr.
there.
Goswami, for you, give the promotion to the post in which the private respondent is there.
Well,
His
it can be
appointment,
adjusted, my lord. They have
how can it
committed-
be adjusted?
They have made a
But
mistake.
you have to challenge it.
My lord.
You have to challenge the appointment. Private respondent. Say that it is you, not he, who should have been considered.
My lord, for the result it was were out.
We are trying to understand
Madam.
what is your prayer, what do you want?
My lord, I think even the post, my lord, which fell vacant
If
during
that
that year.
post to be given, it has to be made vacant. To
Madam.
make it vacant, somebody who is there holding
But
the
it can
post
be
will have to
adjusted
be
against
brought
other
down.
vacancies, ma'am. Your lordship kindly see they have vacancies at their disposal. They have vacancies at their.
But that will run counter to your primary argument.
My lord,
Your argument is that the vacancies which arise in the vacancy here have to be given, have to be filled up by the first vacancy.
no. Adjusted against another person. Then I can be given that post, man. That is all I am thinking, man. Well, your lordship kindly see, this is, the date is, well, contrary to what they submit, extended is the 2 posts.
Where page
Is
number?
that one? Well, I have been.
Seeking promotion to extend registrar. And he got an extend registrar.
I will give you to.
still vacancy here. See the there in the anything.
That about it.
Page
99 also.
99.
Counter filed by us.
Nine.
That is just 5120.
In which writ petition?
Subsequent one also.
3937.
Counter. General information that go to page. Lordship, but steps you follow are there, Lordship, correct. Placing the order, Prabhu court.
Promotion rules. Yes, yes, we have it. 6.2 promotion.
Clause 6. I have spoken to the director shall initiate process for recruitment as per a recruitment rule approved by the BU from time to time, soon after vacancy arise following the registration, retirement dates, and on sanction of new posts. Following methods of recruitment shall be applicable. Direct recruitment, second promotion by selection, contract. Kindly come to next page, that's it, 6.2. Selection from identified feeder grades from among the employees of the institute to a higher post. Any available vacant position earmarked by the recruitment rules to be promoted, to be promotional, may be filled up by promotion. Promotion shall be made as per criteria prescribed in recruitment rules regarding qualification, number, years of etc. Next point, Lordship, modality of 6.2.1. Modalities of promotion by selection. Selection of candidates to a promotion shall be done through the following procedure. 1. Annual performance appraisal report. Second, performance in written test, interview as the case may be. Length of service in present post and immediate lower post at the institute, 5% success. Turn to next page, Lordship, at 6.2.3. Panel drawn by Department Promotion Committee would be valid for 1 year. The date of commencement of validity of the panel shall be the approval date of the competent authority on the panel forwarded by DPC. If any post falls vacant during this period, candidates will be promoted as per merit and considering the category of the vacant post. This will not be applicable in case of fresh sanction of posts, which takes place after advertisement. In case there is a tie, no, this is the case, but this is the crux of the point. Not be applicable in case of fresh sanction of post, which takes place after advertisement. Now, Lordship,
Point 2.3 is part of the rules.
Lordship.
Right? So, exactly. See, very brought up with kids. It will not be applied in case of fresh sanction. Then don't blame. Level is post is available.
The Lordship, the trial.
You're insisting that this particular post.
There are two different rosters independent. One is promotional roster. One is.
So we have understood how this post was available.
Now that
Now this is pursuant to some.
rosters independent of each other.
Correct. We've
One is
understood.
promotional, one is. Lordship,
But it still doesn't become a fresh sanction.
That's why, Lordship, because after the amendment, there are posts. 4 posts were already sanctioned for the promotional post, and 8 posts were sanctioned, 12 posts were sanctioned for the direct recruitment. Now that
No, no,
law
we
that has been changed.
We understand everything. We appreciate that. What we are trying to understand is you would say that this within the current year any vacancy, fill it up from the list, except when it is a fresh sanction. Now this rearrangement of posts from one roster to another roster, fresh sanction.
No, not
Unless-
rearrangement, lots of that. It was in 1920 itself, the post have been separated, two rosters have been prepared. And we are bound to
understand,
go by
but
the
does it
roster.
amount to a fresh sanction?
Yes, lots of that.
Show us some authority that what is the meaning of sanction?
At that time, Lordship, sanction means post must be created. Now, at that time, Lordship, twist post was sanctioned or either they are direct
You
recruitment.
have to define the meaning of sanction. What is the meaning of sanction?
Sanction
Posts
is
are
the
already
process by
there.
which the
Is
post-
there any resolution or meeting by the Board of Governors? It says that this will amount to a fresh sanction or.
I will take your Lordship to the records.
Hmm. Mark it, relevant portion, please mark it.
I'll mark it, Lordship. Lordship, kindly turn to page 33. As per record, the following posts which are lying vacant are to be filled for promotion, DPC. The details of the post are as below. One post assistant register, 16. Total post sanction post 16. Man in position 15. Vacant post 1. Board of recruitment interview. Now the next chart below that. Assistant register, what is the middle frame. Therefore, the competent authority may like to allow initiate recruitment process of the following posts. Assistant register. Sanction post 16, man in position 15, vacant 1 post, direct promotion 15, promotion 50%, man in position recruited for direct recruitment 11, man in position recruited for promotion 4. That was the position. As there are excess man in position appointed for direct recruitment procedure, one vacant post may be filled up for promotion. This is after it is like 50-50.
I understand that, Mr. Kakoti. We are not asking you how the post is available. The question.
That what the roster indicates, every roster, how many posts are there in the roster, sanction posts are there, it's all clear.
Again, we will question is the rearrangement of rosters.
Sir, it has happened, that's the relevant time, 4 posts were sanctioned for in the roster of the promotion post. 12 posts were sanctioned.
Oh, that show us the
Now,
sanction.
what the law says,
Show us the sanction orders.
I'll
Show us sanction orders.
it said that rosters can be contracted and expanded.
Certainly.
Now this, because of 50% post has been created and 1 post is lying vacant, this roster has to be expanded. And
That interpretation, we want to know, is it, are you relying on some authority to say that these situations will also be construed to be sanction of posts? Firstly, how do you define a sanction of a post?
that
Press
is the
sanction of a post.
post has to be created.
If we
By
have
the
to,
competent
that's right, it has to be created.
Not
Now, what is the procedure adopted by the administration to create a post? Now, see, Mr. Sakoti, creation of a post does not determine how the post is to be filled up. Creation of a post will give an avenue for promotion or how to- but if we take a decision, then it will be done by promotion or done by direct recruit.
That is also the authority is taking the decision.
Authority will take that decision.
Taking the recruitment rules and
But-
say 50% now.
But here is a case where this is not a post which was created subsequently. It is a post which fell out because of reorganization of the roster or the quotas.
The logic that taking of the rosters, that becomes independent. How many posts roster has? Supposing one post must be added to his roster, that post has to be created. That has to be sanctioned.
So where is the sanction order?
What's about wait, 34. They don't see that indicates everything. Why the post? Out of 60 number of posts that is at 3 pages, 19 are to be filled up through interview only. Now, next subsequent paragraph. May please advise submit the further course of action on the following. One, to initiate recruitment process for the post of air. This is where relevant for us. Lordship. Recruitment process. Now, next page, Lordship, may turn to. This is sent to the Lordship that HOS CAD discussed in the principle administrative approval or startup or selection process.
This is the selection process. This is not for sanction of the post. There has to be a specific order that yes, it is a freshly sanctioned post.
Sanction comes. Roster it comes, then it post is sanctioned.
So there has to be, according to sanction of a fresh post, there has to be corresponding order or proposal that now that the post has been sanctioned, fresh process has to be undertaken.
Revision under economic weaker section. You don't like subsequent last 2 lines. An internal committee under chairmanship of Dr. T.K. Guha, referred to as assistant DFA was formed for the purpose of purpose. Guha committee has redrawn the exact roster.
Where is that you're reading from?
Reading page 81.
81.
Lines document and if subsequently an internal committee under chairmanship of Dr. Sachin Guha, referred to as Guha Committee, hereafter formed for the purpose of Guha Committee, has redrawn the extent of roster with the existing employees as on 1/5/19 with new cadre structures and has incorporated the EWS. The next parallel. As per suggestion, the external consultant Guha Committee has considered the cadre structure for non-faculty positions. We are concerned with this topic as below, and accordingly separate roster for each post, direct or promotion, is prepared. We fall in, following the categories, we fall in number A, administration, administrative and financial services. Now, it's going on some other, then let's down to page 83. While drawing these rosters, following steps are adopted. Clause 5E. Wherever cadre strength in any given roster is less than equal to 13-point roster has been adopted, and wherever cadre strength is more than 13, 200 roster point has been adopted.
For roster, not the roster.
Roster is, but H says
This is not a case of roster point violation.
the roster is created, some initially it was well thought, subsequently
Side is a roster issue.
no, post has been created in the roster, so this advertisement for the subsequent guideline, which is, the petitioner is claiming. This post has been created in this.
Then you will have to change your rules or to in terms of these rules, there will be reference to rules. They can they can see. But because the rules say otherwise, what we are trying to then everything is all right, but Dalton terms of the rules required to fix up from the
That also, I explain it. I can see it.
unless it is a newly sanctioned court. No.
Can you see that an explanation has been given by the BOT regard to that vacancy here. Page 16. 6 0. Proceedings of 115 BOG.
60.
What one? One
search.
115 BOG. Item number 13.
Yes.
Proposal to follow the DOPT guidelines for the preparation of recommendation of the extended panel of selection. The board was informed that an appeal dated 24/5/23 has been received from Mr. Surendra Mohan Saloy, Senior Superintendent Institute, requesting for reconsidering him for appointment to the post of assistant registrar from the waiting list, which was valid for 1 year, and approved in 110th meeting of the BOG on 31/3/2023. In the appeal dated 24/5/23, appeal by the petitioner, Mr. Surendra Mohan Saloy, Senior Assistant Judge, stated that having somehow managed to come across the BOJ's minute dated 31/3/23, by resolution number such and such, item number 13 today, he has not other alternative but to request competent authority to offer him the post of assistant registrar by BOG approved panel, which at the minutes of IIT 10th such and such remains valid up to 18/2/23. He also stated that the advertisement by number such and such was not only illegal but violative of IIT BOG's directive, which in the first place should not be there. Challenge the advertisement also. In the agenda of meeting, sequence of events, salient points leading to the advertisement of 4 assistant registrars, by circular number dated 5/1/22, and fresh advertisement by circular number such and such dated 12/12/22.
Where is the DOPT?
Here the DOPT is considered. DOPT, why?
No, is that DOPT OM is available?
What the repetition? What's the waiting list? What extent is considered? What is the meant by waiting list?
So your submission stand of the this vacancy was not available. It is made available.
Vacancy is not there in the promotional quota, in the roster, promotional roster.
That's right. So subsequently,
In the promotional roster, every roster has got independent lordship and titles. This promotional roster, a post has to be created. And after creating that post, it's still vacancy.
so therefore, according to you, this is the prescription, not a sanction.
Lordship.
Therefore, it is excluded
And
from the earlier
The life of waiting list, this has been discussed in later
for 1 year.
but 1
That-
year.
That
But
we agree.
the waiting is applicable to not to new posts who are coming.
That's
Each
what we are
applicable-
asking you. We have understood your.
The 4 posts which are already selected, if one of the selected candidates, but if
You are not pressing into service any authorities in support of your contention.
it bring for small adjournment matter, I've asked them to check that courts and why it'll take some time. How this post aspect of sanction. Or if
Let him reconfirm from the report. Seven. Subsequently.
Apply.
Why is the state not releasing 50%?
We have filed our affidavit. It is filed by the Under Secretary to the Government of Assam, respondent number 2, and in paragraph 4, Lordship. Employees of the board have been provided with the benefits of gratuity, leave encashment, and CPF on retirement. They are employees of the Assam State Social Welfare Board and they are not holding any sanctioned government post.
No, but they say that the scheme, 50% given by the state and then take care of their pension remaining.
Lordship may have a look at page 85, Annexure O.
85.
This is one of the letters written by one affected person. Similar case, Lordship. In reply to that, regarding pension benefit to Sri Gyananda Chandra Dev,
85.
85, Annexure O. Regarding pension benefit to Sri Gyananda Chandra Dev, retired driver, Assam State Social Welfare Board. Second paragraph, it is mentioned that without the approval of the Government of Assam Social Welfare Department, the authority of Assam State Social Welfare Board is not under the jurisdiction.
That's what
To
we are
provide
asking you.
pension.
Why are you not approving it? Why not approval?
Lordship, now the board is also dissolved. The central and the as well as the state board, social welfare board, both are dissolved.
Now, Mr. Soikia, if the board is dissolved, assuming we issue a direction for the state share, where will they pay the money?
For them, for the body. To for them, for the body. The regular salary.
It's for the board. Six. 6 and 7. Who's for 6 and 7? Six and 7.
Come.
For the social welfare department. Earlier, MD Bora here. State respondents.
We don't appear for the board.
No, it is reported. Steps were not issued to respondents 6 and 7. You're saying that the board is dissolved. Soikia is saying it is still there.
No, Lordship, the 4 of the staff employees, Lordship, they have been attached with the Directorate of Social Justice and Empowerment. In addition to their assigned duties, the director, and one of them is also absorbed in the Directorate also of the Women and Child Development. One person has retired.
Mr. Soikia, you say board is there, they say it is dissolved.
Now, but was case was filed long back. It was filed on.
No, we are on that. You are.
That's it. I will, my lord, I will.
We are coming to your prayer.
My lord, 2021 case was filed.
Correct.
Now they cannot avoid their, because they cannot avoid their responsibility. My lord, can you see?
No, please explain to us. Please explain to us your prayer in the writ petition.
My lord.
Page 23.
My lord. First, why the chief secretary chief concurrence of 50% of the company benefits to be involved as soon as the concurrence is.
So you are asking for a direction to the state to give concurrence to the proposal. Once the concurrence is given, the money will have to be given by the state.
My lord, because 50%
Now
they have to
the money will be paid by the state to whom?
social welfare board.
They say it is dissolved.
But now they say, but the government is not job, government is there. They cannot avoid the responsibility.
Very well, but you have to work out a method. Assuming we allow you.
It's correct, but one aspect. Suppose the government, a government is dissolved. There is no government, presidency has come. But can the government absorb their duties? That we are no longer in government, we cannot pay our salary. And we should pay 91 for a one. Page 91. So the central government has given money, 21 number of states have given their concurrence. Why not the government of Assam? They are most negligent. It's 91. Issued by the executive director. That's it. On 12/6. As you are aware that the central social welfare board is implementing various programs for the development of the women and children through the state social welfare board. State social welfare boards were set up with initial consultation between the central board and respective state governments. The expenditure on establishment of the state boards is being equally shared by the central board and the respective state government in this ratio of 50-50. The employees of the state boards are governed by the service rules of the state government. We also on the major query during the course of a hearing at the admission stage whether we are government servant or not. The employees of the state boards are governed by the service rules of the state board. Since then, that we are the government employees.
Where is your appointment order? Your services being governed by state board doesn't make you government employee.
So just I am saying.
Then why are you asking for the government to give you their share of pension? You are entitled to pension.
Because they say that when our petition was booked.
Mr. Soikia, we are absolutely giving you audience to listen to your problem, but unless you are able to apprise the court, say what reliefs you want and the relief that you're praying for. we are helpless to allow the writ petition, we will be compelled to dismiss your case.
No, no, let me place my submission also. What you kindly see, that page 35.
Yes.
See the composition of the board. Walk back, kindly see my lord, page 35. Roman 7. The employee of the state board will be governed by the state government rules in terms of their service conditions. State board will also follow the state rules in case of the other financial and administrative matters. So we are government employees, they are bound to pay.
No, no, if you're government employee, then you seek your claim under the pension rules.
My lord.
Why are you asking for the proposal?
Because what? Because they say,
If you are a government servant, you are governed by the pension rules.
I see one thing. How the government, other government in India,
No, other government is all right, but there is an option given by the central government that in the event the state needs to bear the expenditure,
because of the fact that we are
they have in their wisdom they have decided not to bear the expenditure.
similar case has been decided by by High Court. That when the employees are rendering service, and are superannuated, whether who the government or the social welfare department, they have
Let
to
us have a
pay
look at the judgment.
they have to pay this pension.
Let us see the judgment.
Yes. Why they are entitled but under the pension scheme? I have my also pension. And the governor can under Article 31, under Rule 31 can also relax.
Provided you are a government servant.
Why not? What they are throwing the basket down. And the government will say, you are not our employee. They will say, you are not our employee. Where the employee go, my lord? Where the petitioners will go? And because we are working under the social welfare board, and similarly situated persons throughout the country have been given this benefit. Article 14 is violated, my lord.
Where is your appointment order?
But they do not say that we are not their employees. Their affidavit, they admitted that we have been appointed by them.
What's your appointment order? That is why we want who is the counsel for the board. Your colleague had appeared for all the respondents. Today you are saying you are not appearing. Kindly check up the order. This order of 23/8/2021. Counsel, government advocate, appears for state respondent. Both respondents are required a representative. Is there anything before that the board has been resolved?
Should be, I have one, it is the rationalization of Central Social Welfare Board.
order or created?
American division. 17, again they have, my lord, got this vote on, page 39, my lord, of my requisition. Secretary, Government of Assam. Expiry of the term of existing members of the Assam State Social Welfare Board with effect from 2015, the Governor of Assam is to reconsider the Assam State Social Welfare Board in excess of the powers conferred under Article the first 4 of the rules governing the composition and function of the State Social Welfare Board for a period of 3 years with immediate effect and until further order. So it was an order until further order. This order was issued in 2017. And then while this petition is pending before the Honorable Court, they say that now board is zero, we cannot pay you. That will not hold the appeal because the government of Assam, my lord, they neglected. They did not look to the matter. For that, these employees should not suffer. My lord. And secondly, Lordship, page 39, Lordship.
That is reconstitution of the board. We're asking you how was the board brought into existence?
What is not then? Here under the last proposal, the government, the council, Rana Council of the government was put this question. And my lord, they did not say that we are not the employees under the government of Assam. Also, can we see this increment, then promotion, all are given by them. I have annexed the copy of promotion also. They've been telling that you will not get anything and not get your pension because the Honorable Supreme Court is prohibiting on one case now. Working on a Posot case 1976, Supreme Court 1971, held that the employees must be given the pension. Question of some delegates should not be looked into. That means my lord is governing the field now to the country. Employees after retirement.
We are appreciative of your thanks, but we are not being able to formulate the manner in which you want the order. It is like saying that there is so much of difficulties, discomfort everywhere. High Court must pass it down. Like that. You are claiming for pension. You first tell us how the service was brought into existence, number one. Number two, show us some of your appointment letters. Have any letter indicating on which date you will be superannuated?
Sorry, yeah. Not a problem.
Government, you tell us what is the status?
Lordship, our contention is that
Uh.
they are not holding any sanctioned government post.
Forget that. You tell us how these boards were sanctioned. It is sanctioned by government,
Lordship,
state of Assam.
Lordship,
Under what provision, under what rules? Under
Lordship,
what
that
notification?
instruction I'll have to get, Lordship.
Get it.
But,
Get it by day after.
and Lordship, the state government had not agreed with the proposal sent by
Forget
the
your
central
affidavit.
government.
Show us from your record.
Lordship,
Show us from the records as to how the board was constituted
Lordship.
and how the appointments were granted. Show us. Thursday. So, yeah. We'll continue on Thursday. Get your instruction.
But that promotional orders are here.
How are they relevant? Your initial entry into service is required. Your exit from the service is required. None of them are here.
No, they were directed to police the records also. They did not police the records.
Are your clients not in possession of that? They are asking for pension.
Hello. I make it very.
Ah.
Base 42 is another.
No, you get this detail. Let us see the documents which are necessary for this court to examine the matter and pass an effective order.
Lordship is correct.
Ah.
100% correct.
Then if I am correct, then why are you arguing?
Appointment letter and secondly, Lordship, they are regarding this constitution of the board, let them place it, my lord.
No. You show us your appointment orders. Yeah, ask your clients to produce the appointment orders, the orders on which they were superannuated.
Lordship, they kindly give me 7 days time.
7 days. We'll have it
Because
on.
I have to call, inform them.
We'll have it on 19th March. The counsel for the parties are permitted to complete their instructions with specific instructions with regard to the mode of appointments made. So, institution of the board by a set of rules, bylaws.
Yeah, there, Lordship.
Office memorandum. For council would also eight, 6 and 7. 6 and 7. As it is submitted by them that the board have been resolved. Council will also place the official order passed for constitution of the board. Stone 19. 19. Academic, teaching faculty. Yeah.
Item number 20. Heading. AICT Act.
Still benefit.
Upgradation.
Still upgradation.
Financial upgradation.
This is on the basis of the AICT route.
AICT rate.
Served for how many years?
More than
More than 2 years.
Yeah.
Then there was an advertisement, right, and you got selected as the assistant professor.
same course.
So this page number 75, you're eligible for next 5 years.
For this regulation,
When is the contract service being taken into account? Adding the contractual service
I'm adding the contract.
plus 3 years.
Yes, no, 2 plus 3 years.
That's what we are asking you.
Not in my,
So in principle, it has been granted.
in principle it has.
Then what is the problem?
Number, 2008, only that we put. Their response, certification. Kindly speak up. Please say no.
Same number.
First to one notification, Your Lordship.
Slight difference of one digit. If you look into slash 2016. These are two separate notification issued on the same day.
Here counter, Your Lordship, and they said no problem. They did not.
Six. This rejection was done by whom? By the Yes. Itself a binding or it has to be adopted? Guidelines or binding? Under Ministry of Human Resources.
To make regulation is that section 23.
Section 24, Your Lord.
The credential. Page 85, my lord, the counting of first service, my lord, for direct recruitment. Page 80.
gap, my lord. One gap. Previous appointment will not for any duration or an ad hoc or
One thing, we want one thing. The supreme body is the Board of Governors. They have taken a decision.
my lord, the only detect. I file affidavit, my lord.
No, you come to page 100.
Yes, my lord. Yes, ma'am. I have done so.
And 101,
I've done so.
the resolution.
Yes,
Very clear.
yes, ma'am. But here, my lord, we have filed affidavit, my lord. The affidavit, we have.
What are you stating in your
Yes, my lord. Yes. Applied for the same, the duty scrutiny is found among criteria. Therefore, they are not considered for CS promotion. Moreover, one of so was applied so.
So if they're not, then you pass a specific order.
Yes.
Why are you clarifying by way of an affidavit?
Yes, my lord.
The rejection is with regard to some communication dated 31st of January 2017, which according to them has not delivered. Somebody is promoted. Why should we direct you?
Lordship, this
Why should we direct?
sometime
Why should we take time? It is for you. Tell us that no. No, no, no. Just deny it by way of an affidavit.
find the yes,
Try to
I want to just do one thing. They are minus contractual appointment. Yes,
whatever their
yes.
case may be, it is placed before the BOG. BOG
I
has
understand,
approved.
I understand. But there's expert is here record put in Robert Court minor. Base 55 minor. 55, they are regularly appointed. Minor. Yes, repeat. Regularly appointed minor on 6 February 2015 minor. And before that minor, their extension was minor, this place 46 minor. This extension was minor 31st December 2014. That period minor, this it was not continuous minor.
That the BOG will have to decide.
Yes, ma'am. Yes, ma'am.
So they have not taken an objection to that.
Minor, this
Instructing you. Who is your instructing officer? Registrar.
register file is actually.
Registrar filing is everything. What is the role of the registrar insofar as the BOG is concerned? The member secretary. So is it not his duty to bring it before the BOG that there is an error, this is not fulfilled, that is not fulfilled? Why is he trying to expand this by way of an affidavit? How dare he instruct you to the contrary when he is the member secretary of the BOG which is approved? Have any ire against the petitioner?
No,
And
madam.
if he has,
No, madam.
we are not concerned.
No, madam.
The member secretary, he knows what decision the BOG has taken. If that it is wrong, you should refer it for reconsideration.
That is
Then, yeah, has he done anything? This decision of the BOG was taken when? 17 March 2022, we are in 26. 4 years, what was he doing? You are entitled to take leave if you wanted to. Pray for leave that we want to reconsider this matter. We are tempted to call him before the court and explain his conduct. We are tempted, really. He's trying to expand the scope by way of filing an affidavit. Without explaining why these matters could not be reconsidered by this again. Day after tomorrow. Try to come.
Krishna is facing a removal and that removal we have challenged the court. So on 19/9/23, the first show cause notice was served on the petitioner. And on that same day, the petitioner refused because the petitioner has asked them to furnish a show cause in a Hindi language. So that was given to the petitioner on 16/11/23. And after that, 10 days was given to the petitioner. And immediately on 27/11, the petitioner submitted his reply against the show cause. Then on 15/12/23, the first memorandum of charge was given to the petitioner. And then again on 21/12/23, that first memorandum of charge was withdrawn. And on that same day, on 21/12/23, the second memorandum of charge was given to the petitioner. And therefore, the first hearing date for the disciplinary proceeding was fixed on 25/11/23, whereas the petitioner attended that first hearing. And after that, the petitioner was granted 10 days sanction leave. And thereafter, the petitioner went back to his home where he met with an accident. And thereafter, immediately the petitioner intimated the inquiry officer and the disciplinary committee regarding the same through WhatsApp that letter is annexed.
Was it before the court before?
Yes.
Challenging the same proceedings.
That at that time he was not even being entertained.
The order of the court is to
Yes.
reinstate him in
Yes.
service.
Yes. In that proceedings, your lordship will find is that just on the basis of some preliminary inquiry, they were never been given an opportunity of being heard. And they were straight away been removed from the service.
All right.
So that we challenged and we got reinstated. And following that, again this second.
No appeal against the judge. Has any
No,
appeal
no.
been filed?
And thereafter,
Another
second-
proceeding.
Yes. Another proceeding. Thereafter,
This is a fresh proceeding
it's the friend.
or the earlier one.
Fresh.
Fresh one.
That regard, your lordship has called for the entire record and to get the same translated. So I think they have funded. It was actually on the Hindi. Your lordship has asked for a translation. The messages are in English. The evidences are in English.
You say? The writ petition.
Speaking order and starts from page 85. And it's the last page, it says, therefore, the second paragraph.
Yes.
Therefore, the strict punishment is warranted against the party charged for this act as such as per the power conferred on the undersigned in Schedule 3rd of the RPF Rules 1987. I hereby order for removal from the active service with immediate effect upon the party charged, city Arun Sharma. So and so.
Then again, then you define the period.
The Lordship may also see our letter.
Time frame that was not done. Subsequently, they filed a representation, but the actual appeal they have not never preferred. The petitioner has never preferred within the stipulated
But
period.
prior to that, your Lordship, even when the intimation was being made that he met with an accident, that was not even considered by the inquiry officer.
So the
They are not. The order itself is stating. That was not preferred. Last paragraph of the 88th page.
why did you not file the appeal?
Section 9, subgroup 2.
Fine. Fine.
That was not done.
But if there is a delay, still the delay.
Appeal against the removal will come much more later because the inquiry proceedings when it got started. So actually, I attended the first hearing. Then subsequently, they given me a sanction leave of 10 days after I met an accident, and then I couldn't appear on the next day. And just because I couldn't appear, they went ahead with terming me an ex parte and straight away removed me from service.
That was in the earlier round.
No, not in the earlier. This is the second, on the second process. This fresh one. And the rules also says that if there is a reasonable cause being shown, then they cannot move ahead with terming me an ex parte. The Lordship will see 153.9, Rule 153.9.
So
The-
go and file an appeal because these are factual issues. They call for evidence. Have understand why you could not.
That is what we are wanting. That if your Lordship may just remand this matter back, we are ready to appear.
No,
We
you-
are ready
you
to
have already-
face the
You
proceedings.
did not file an appeal. Who prevented you?
No. Your Lordship, the appeal will come much later. The thing remains. So once they
You
have
are
started
before this court against which order?
this removal order.
The page 85.
Yes.
So page 85 is the final order passed by the disciplinary authority.
But I was termed as an ex parte.
Whatever it may be, you have a right of appeal against such orders which is apparent from the order itself. That
But-
you may prefer before the appellate authority there why you are agreeing with this order.
No, but your Lordship may just for a moment, if your Lordship may just see the rule 153.9 of this RPF rules.
Nine.
153.9. It says if the enrolled member charged fails to turn up on the day fixed for the start of inquiry and no reasonable excuse is offered for not being present on the fixed time and day, the inquiry officer may commence the inquiry ex parte. But where after we met with an accident, we have given them, we have intimated them.
You urge this before the appellate authority. That's really what we are trying to tell you.
So
You have to explain why you have not taken recourse to statutory provisions under the Act.
So now, so in that case, you're
Either you say that there is a violation of some rules which the appellate authority cannot do, the appellate authority is not there, or any other reason why the appellate authority is not the appropriate forum, then we can hear your matter.
so then in that case, now we have submitted the representation recently.
Where
So-
is that representation?
Representation. The representation is on the record.
No, in your petition,
That is not annexed here. That is much later. The representation was given.
after filing,
Yes, that was given.
you have a copy here. File it in terms of the prescribed format.
In that case, your Lordship may just direct them to consider our application.
Heard. Comes into the department. Constable.
Yes,
Constable.
constant. Surprisingly, your Lordship, the charges for which he was being charged.
The order was
seven.
Act is
Act is 1957 and rule is 1987.
So, but if the owner make it he submits that the dismissal doesn't be,
Yeah.
You know what? Respondent number 9. Assistant secretary
Respondent number.
will appear before the respondent number 9, namely the assistant secretary.
No, you actually respondent number 7.
The
The,
disciplinary authority.
yes, come regional security commissioner.
No.
He is the appellate
Respondent
authority.
number 7. Along with a certified copy of the order. And
agency suspension or the safety.
suspension order. File an appeal under the provisions of. File an appeal. File it. File an appeal before the, as per the provisions of the. Clear provision.
14.
File an appeal.
in page 57, Your Lord.
Respondents have filed. Thank you. Let's try for appeals again.
Page 10,
Huh?
preliminary husbandry and field assistant, veterinary field assistant.
Field assistant.
Yes, veterinary field assistant. Yeah, but-
Right. Again. That's good.
What is the delinquent?
She was supposed to come by 2:30. They fixed it at 2:30. Yes. Why can't this issue be decided by the tribunal? Decided by the tribunal?
Yes.
What is the issue? We constitute the tribunal, you'll have full liberty to argue before the tribunal regarding it.
established even after there is an arbitration clause, the lordship needs to that it is an arbitrable or not.
The later judgment of this, of the apex court, simple. The arbitration.
Further, a reference to- otherwise the whole process, I'll cite,
Arbitration.
I'll just cite a judgment if your lordship may allow. And further, if your lordship further asks, I'll just refer I'll just refer few provisions as well. Apart from that, the definition of court as per Arbitration Act. Section 2, subsection E. 1. The definition of court. Definite court, the place of an arbitration other than international commercial arbitration. The principal civil court of jurisdiction is a district in a district, comma, and includes the High Court in exercise of its ordinary original civil jurisdiction, comma, having jurisdiction to decide the question for the subject matter of the arbitration. If the
Give us a copy of the act.
yes, I'm having. I'm having an extra book here also.
Try to see if it is
I'll-
there.
I copied 2 books here. I can.
Try to see if it.
Section 2 definition. Section 2 subsection E, subparagraph 1, Roman 1. Arbitration other than international commercial arbitration, comma, the principal civil court of a district, comma, and includes the High Court in exercise of its ordinary original civil jurisdiction, comma, having jurisdiction to decide the question forming the subject matter of the arbitration if the same.
You are raising the question of jurisdiction before this court. This court
Yes,
doesn't
Your
have the jurisdiction.
This is also one of the issues. This
No, no. Primary issue to decide if the court doesn't have.
Yes, Your Then I'll refer to. Yes, I'll just read this section. This the same section, the paragraph 1, definition of court.
No, we have seen there.
Yes, and simultaneously I'll refer to section 430 of the Companies Act because it's a matter of a company. I'll refer section 430 of the Companies Act. What the act says. Companies Act 2013.
how is this provision relevant?
Because what is the matter?
This is to say that civil court will have no jurisdiction.
Something that and the matter is pending as well. Before the
Maybe, but how is this relevant? Under IBC,
No, it's not under. That only governed by section 430.
the bar against the civil court. Thereby, then with regard to the subject matter under the NCLT, can't have a civil suit or an ancillary matter, you can't have a civil suit.
Regarding this,
Maybe, but how? Sabi 11.6. Right, this point or don't press this point.
I have a judgment. But it is of CLB, not of NCLT. But with reference to same provision under which it is pending before NCLT. Page 1. The dispute brought before the company law board invoking section 397, 398, that is right now 241, 242, Your Lordship, of the at all referable to a private tribunal via an arbitral panel for resolution. This is my case, Your Lord, ultimately.
Your application is under
Section 59, 241, 242, and 213 as well. Because there are many prayers which we have prayed for before the NCLT. Arbitral tribunal does not have the power like investigation, direction upon the registrar of companies. There are criminal cases pending between the parties. We have prayed further a prayer against the auditor and the professionals as well. We have made many prayer against the bank as well
for which they are not even a party to this
Where is the finding of the court with regard to this question?
matter is pending, your lordship. There is no fine. Okay, in this judgment, issue, the lordship can refer. First of all, I'll rely paragraph number 7. This is the background.
Paragraph 74.
Yes, correct. Sixty-eight is also there, your lordship. 68 or 67 over here. That in my edition, it's paragraph number 70. It starts from a civil court jurisdiction. Well, exclusion is not to be readily inferred unless certain conditions apply. This is also a relevant paragraph, your lordship. I have just marked that relevant paragraph from pencil, your lordship, in that. Not
Power of the tribunal, you know, it's 242 at present. Software application.
Arbitration is very arbitration. Arbitration.
They are referring.
So if there is a share purchase agreement dispute, go for arbitration. Right? What's the agreement? Tribunal, what application thing that what
But as in my reply to your lordship, without an issue, I have attached water based. I am saying my share certificate were bought without consideration. My share certificate were in company, they have forged my signature and taken custody.
where is the notice for arbitration? Fine.
Order copy is attached with my petition or I have been served. Order sheet.
that has been triggered, how this arbitration petition comes into picture, and it is there in their own pleading. I can.
You can join us in hybrid mode.
Don't read through.